Good evening. Thank you for sharing your time by attending tonight's webinar. My name is Greg Eunice, and I'm Senior Associate Vice Chancellor for Development, and I oversee the charitable gift planning and annual giving across ECU, including the very special Medical and Health Sciences Foundation. In the interest of your valuable time and after a long day, this session is held to 1 hour to be mindful of your busy schedules. This presentation is designed to afford you the opportunity to ask questions by chiming in during the presentation when that question is pertinent, or through the question box located on your screen. Please use the format most comfortable to you. It is our goal for this to be interactive, thus feel free to get your question answered. Thank you to the highly regarded professionals at Warden Smith, who the Medical and Health Sciences Foundation at ECU has had a long-standing relationship with on their leadership of their foundation board. I'd like to thank them for sharing this outstanding and timely information for the benefit of the Brody School of Medicine and resident alumni. I'd like to turn this over now to Dr. Herb Garrison, Interim ECU Medical and Health Sciences Foundation President.
Thanks, Greg. My name is Herb Garrison. I'm the Associate Dean for Graduate Medical Education and a Professor of Emergency Medicine. And a few months ago, Dr. Stacy asked me to help with the foundation, and it's been an honor to do so, and I've learned so much. And I want to start by welcoming y'all, and thank you for being here, and also noting that the chair of our foundation board, Tom Robinson, is with us tonight. And Tom, thank you so much for being here. You know, we're trying to do things a little bit different with the foundation, and one of the things is to offer some services to our alumni and to our constituents instead of just asking them for money, although we're going to do plenty of that. And one of the things we thought of was, let's do some teaching about estate planning. And we talked about it, and I said, doctors really don't care about that for two reasons. One, no estate, and two, no plan to die. And that's just how doctors are. They look around and say, I don't have a big ranch house. But in fact, we all have an estate, and they know they do, and we're all mortal, and they especially know that. So this is a really important thing. Then we went to Warden Smith and said, who's your best estate planning person? And they said, without a doubt, it's Greg Peacock, and we're so thrilled to have Greg with us tonight. Greg is a specialist in estate planning. He's rated by his peers as a preeminent in his field, and we checked that out, and it's true. He's a graduate of the University of North Carolina at Chapel Hill and the Wake Forest Law School. And without further ado, Greg, we'll turn it over to you, and thank you in advance for enlightening us tonight.
All right, well, thanks, Herb, and to everyone. So as Greg Eunice said, we would like to try to keep this discussion tonight as informal as possible, and probably would be a little bit easier to be an informal if we were all sitting in a room in Greenville somewhere. But you know, due to this world we're now living in, the Zoom is where we find ourselves. So you know, I do have some thoughts you know, that I will share with you all, but I often find that the most effective estate planning discussions are ones where the participants get involved, they ask questions, and since lawyers charge by the hour, this is an opportunity to get a little bit of free legal advice. We also will try to leave some time for questions at the end, but if you do have a question as I talk, honestly, please interrupt me by either unmuting and just sort of blurting out, and we'll stop and listen to you, or by using the feature where you can pose a question in writing. So since this is an estate planning talk, I would be remiss to at least not discuss some of the basic estate planning documents. Hopefully we will spend most of our time talking about a little more complex matters, but I wanted to just start with sort of the basic structure. In my opinion, every adult should have at least a basic estate plan that would be comprised of documents such as a will. And I know everyone has heard of a will, and everyone knows what a will is. it's basically a legal document where you direct the disposition of your assets upon death. And those wills can take lots of different shapes and forms. We're going to come back and talk about wills in more detail in a few minutes. But that's, generally speaking, sort of the primary document in an estate plan. As you know, will is planning for death, but a lot of estate planning is also planning for incapacity. And a lot of times I tell clients, I think planning for incapacity is just as important as planning for death, because you want to make sure that the legal documentation is in place to make sure that someone else is able to handle your affairs if for some reason you're not able to do so yourself. And so those documents that typically include a durable power of attorney. That's a document where you designate an individual, a bank or trust company, or a series of individuals and or a bank or trust company to make legal and financial decisions for you if you become incapacitated. So that ranges from paying your bills, selling your house if that's what makes sense, carrying out certain rights that you may have in medical practices, things of that nature. You all know more about healthcare powers of attorney than I do. Though we draft them, you all see them during your practice maybe on a daily basis, or at least on a frequent basis. That's obviously a document where you designate someone else or a series of individuals to make healthcare decisions for you if you're not able to make those yourself. We follow that with an advance directive for a natural death for those clients who wish to state their desire that their life not be prolonged by extraordinary means if your condition is hopeless. And we typically will round out that basic estate planning package with a very broad HIPAA authorization. Again, you all are more familiar with HIPAA than I am, but in essence, as you know, most medical providers ask new patients or current patients to either provide or update their HIPAA authorizations, where it would specify to that particular practice a list of individuals that the person is designated to have access to healthcare information. So this broad HIPAA authorization that we would prepare would apply to any healthcare provider. So let's say that you need a healthcare provider after you're incapacitated and no prior HIPAA authorization was signed with respect to that particular medical provider, then this is when this document that I'm talking about would come into play. So that is, that's sort of the basic package: the will, the power of attorney, the healthcare power of attorney, the advance directive, and a HIPAA authorization. Sometimes that will gets expanded a little bit. It may not only be a will, but it may be a will and a revocable living trust. And a revocable living trust is a document that may be a little more sophisticated than a traditional will, but it often is used in situations where there's a desire to avoid the probate process for a number of reasons. So the gist of a revocable living trust is that it's a trust that you create during your lifetime, and it then provides at your death what would happen with your assets. So in some ways, the revocable trust sort of becomes the meat of your will. And if you have transferred assets to that trust during your lifetime, then at death, those assets will pass to your beneficiaries without having to go through the probate process. And that can be beneficial for a couple of reasons. One is there is a cost associated with probate. The clerk of court has a fee, which really isn't too bad. But then a lot of times an executor hires legal and or accounting counsel to assist, and that can create some cost. So if the assets are in a revocable trust prior to death, then that often results in a little bit more ease of transition without the court waiting periods and without the cost associated with the courts. Another reason why a revocable trust could be an important part of an estate plan is that if an individual owns real property outside of North Carolina. So when a person passes away, there must be a probate proceeding, not only in the state of residence, but in every state in which the deceased individual owns real property. And so, and that even in a real property interest would include most timeshare interests. So I can tell you from experience that a lot of times those out-of-state property interests end up costing more to deal with upon death than a person's primary estate, because you're dealing with out-of-state counsel and all of the inefficiencies that go along with that. So whenever a client has real estate out of state, we typically advise them to create a revocable living trust, transfer that out-of-state real property into the trust, so then therefore upon death, there does not have to be a probate proceeding in that other state. A revocable trust also can make a nice receptacle in certain instances for life insurance proceeds, sometimes IRA or retirement plan proceeds. And we're going to spend a good deal of time talking about IRAs and retirement plans here in a few minutes, and whether it makes sense to name a trust or not name a trust, depending upon your facts and circumstances. So I wanted to take a little bit deeper dive into wills and trusts. As I said earlier, those are documents that provide an opportunity to direct the disposition of assets upon death. And so these wills and revocable trusts can take all different shapes and forms. It could be a very simple will where a person leaves all of his or her assets to another individual. It could leave assets among a number of individuals. So it is, or it can be more complex. So I wanted to talk about a few instances that generally require a little bit more complex will, trust, or estate plan. So the first one deals with estate taxes. And estate taxes seem to be a pretty big topic around September, October, November, every 4 years. And this round of elections is no different there. So we're not going to get into any political discussion, thankfully, tonight. But I did want to talk with you a little bit about the estate tax. So essentially, when an individual leaves assets to a spouse or a qualified charity, there is no estate tax, no matter what dollar amount passes, whether it's $100, 100,000, or 100 million. If you're leaving if you're leaving assets to a spouse or a qualified charity, no estate tax at that juncture. The estate tax kicks in when assets are left to a non-spouse, non-charity. So, in many cases, that would include children, but certainly does not include children in every estate plan. Obviously, it sometimes includes friends, nieces and nephews, siblings, any variety of individuals. The current estate tax exemption is $11.58 million. So what that means is that if a person's estate is less than that amount, then there is no estate tax upon death. If a person's estate is larger than that, then the estate tax rate is 40% of the overage. And one thing that is important when we're talking about estate taxes and whether it applies to any given person or anticipated estate is just to spend a minute or two talking about what comprises an estate. So clearly your estate is comprised of real estate that you own, stocks and bonds that you own, cash, checking account, bank account, your IRA, retirement plan, just pretty much any asset that you have access to is going to be included in your taxable estate. The one asset that surprises folks sometimes is life insurance. So if you have life insurance and you still have the ability to change the beneficiary, you own the policy, et cetera, then the death benefit is also subject to estate tax. And so oftentimes clients may think that they don't have an estate tax issue. Then they factor in the fact that they may have sizable insurance policies depending upon where a person is in life, and then realize that we may need to give a little bit more attention to that. So this $11.58 million exemption from an historical perspective is large. Yeah, I've been practicing for 24 years. When I started practicing, it was $600,000. A few years later, it started increasing in small increments through the years. But about 4 years ago, the estate tax exemption went from essentially $5 million to $10 million. It's 11.58 because during the same time that the exemption was increased, it is increased annually for inflation. So the tax books actually say we have a $10 million exemption, but because of inflation over the past number of years, it's actually 11.58. Now on the tax books, this $11.58 million exemption is scheduled to decrease by 1/2 of that amount January 1, 2026. So in all likelihood, we'll have a little bit of inflation between now and then. Let's say that puts that exemption up to 12. Then the tax books say January 1, 2026, we would then go back to a $6 million exemption. So the reason why I'm talking through that is, it's important that, $11.58 million seems pretty large, and it is large. $5 to $6 million seems large as well, but a lot more people are caught in an estate tax situation if that exemption does revert back to the $5–6 million range in 2026, particularly when you start including retirement plans, life insurance, and things like that I mentioned a few minutes ago. But the sort of the big kicker is, we may not have until 2026 for that exemption to go backwards. Certainly if the makeup in DC looks different come January 1 or 11 or whatever inauguration day is, then if it does look different in DC, then certainly the estate tax is one of those issues that is being highly discussed during this election period. And there have been proposals where that might go back to even like $3.5 million. So even if a person is not in an estate tax dilemma at the present time, we encourage clients to keep to keep their eye on the ball, which may include doing some planning for the what ifs. What if down the road my estate is larger? What if down the road the exemption is decreased? What if I become incapacitated, the exemption goes down, and I'm not able at that point to change my estate planning documents to take into account future law changes? So there are things for individuals, like physicians, whether they're at that point now or whether it's anticipated through the years they may get up in that range, that we want to start talking about things that can be done to reduce the tax. Because like I said earlier, when it does apply, it's 40%. It's a huge chunk of change. Other reasons why so let me get back and say, so if estate tax is a consideration, then there are provisions that we can include in a client's will or trust to try to take better advantage of these exemptions in order to ultimately try to pass more of your assets to your ultimate beneficiaries without taxation. Since we are limited to about an hour tonight, I'm not going to go into the ways that we do that. We certainly could get more specific and I could walk through some examples, but I think the idea for tonight was for me to talk with you more about several different issues rather than taking an overly deep dive into the one issue of estate taxes. But I'm happy to answer questions now, or at the end, with respect to estate tax issues for sure. So basically I was talking about why a will or trust may not be a simple basic will or trust. And the first was estate tax considerations. There are other considerations. It could be that a client has a situation where a special needs trust needs to be considered for either a spouse, a child, or another beneficiary. And that's an important part of our discussions, with clients. With physicians, a huge issue that we discuss is asset protection. And so again, we could have an entire talk just on asset protection, and maybe we'll do that in another sitting. But just sort of a simple thing that can be done in a will or trust is if we're talking about a married physician, and it actually applies even if both spouses are physicians, but for one spouse to include a trust for the benefit of the other spouse. So in essence, if a physician is the surviving spouse, and if the deceased spouse left assets in trust for the physician spouse, that trust can be created in a way that, one, the physician trust can still control and access that trust. But that trust can be designed as an asset protection trust, which would be protected from judgment creditors, if a medical situation ended up, in a trial and, judgment situation. And it's also very, very beneficial if we are mediating, in these, medical malpractice cases, to be able to illustrate early on that the physician does not have a lot of assets that are subject to a judgment should the plaintiff decide to take it further. For example, IRAs, retirement plans, are protected assets. So those enjoy asset protection just by virtue of the fact that they are an IRA, they are a qualified retirement plan. A lot of times real estate that may be owned jointly with a spouse is also, in most cases, would be exempt from judgment creditors. But the issue a lot of times is, what if, what we were talking about a minute ago was if the non-physician spouse passes first, then what was a jointly owned piece of property that would have been protected from creditors all of a sudden becomes the surviving physician's sole asset, where there's zero protection. The homestead exemption, sometimes we hear people talk about homestead exemption, and the homestead exemption is something in some states. In North Carolina, it's like $10,000. It's not even, we don't even talk about it with clients because it's so meaningless. So again, if real estate, houses, beach houses, investment property, brokerage accounts, things like that, if those pass into a trust for the physician spouse, those could be protected, in the unfortunate event if the non-physician spouse dies first. And again, I know a lot of times we see double physicians, meaning husband and wife as physicians, and so these like cross trust could be structured in that scenario as well. Another type of trust that we do an awful lot of is lifetime trusts for children. So these lifetime trusts for children are trusts that are created under a standard will or revocable trust. So what I'm talking about right now isn't creating a trust for children that you're creating right now and putting money aside for a child right now. That's not what I'm talking about. I'm talking about creating infrastructure for down the road at the time that you pass to create some trust structure for children. A lot of times with young physicians, we're talking about creating trust for minor children or young children to ages, 25, 30, 35, 40, whatever, the client thinks would be the appropriate age. And a lot of times we sort of stage those distributions, a third at 30, a third at 35, a third at 40, something along those lines. But what I'm talking about now is lifetime trusts, which you could consider for minor children at this point, but really, adult children. So the concept is, when a person passes away, and if they're leaving assets to children, either on a first death or second death, or in an unmarried situation, that those assets, if left outright to the individual, would become an asset of the individual. And probably the thing that I hear in my conference room the most is, I want to make sure that I'm leaving my assets to my children or my loved ones. And usually that comes with, or is followed by, a statement, and I love my daughter-in-law and son-in-law, but I want to make sure that that daughter-in-law and son-in-law doesn't end up inheriting any of my assets, particularly if something ends up happening, in the marriage. So these lifetime trusts, do a lot to protect those assets. Again, a child, if there's not a reason for a third-party trustee, the child for whom the trust is created can actually be the trustee and can control those assets. But then the assets in that trust would be protected in the event of a lawsuit, including lawsuits that happen in a divorce type situation. Since I'm talking to a group of physicians here, I will tell you that I often have talked to my physician clients whose parents I don't represent, but I've given them advice to, that if the physician's parents are still living and anticipate a reasonable inheritance, that sort of the best advice I can probably give my physician client is for that physician client to talk to his or her parents and ask them to create this type of trust that I'm talking about in their estate plan, so that when a physician child, in this case, or other beneficiary, receives assets from a parent or otherwise, those can be in a trust that is protected in the event of a bad medical occurrence. So most of this is not sort of one shoe fits all. It really sort of starts with a discussion about what is the family makeup, who are the potential beneficiaries, whether family or non-family, whether charity is a consideration, and we're going to talk about that in more detail in just a minute. And just talking about the assets, talking about the concerns, and then trying to develop the plan. Many times for young clients, and the same would be for young physicians, it might be pretty simple. But as life goes on and as assets get more complex and assets get larger and life happens, then oftentimes some of these other techniques that I've talked about become important. And it's not like everybody's got to have every single one, but some of them become important for certain individuals. Excuse me. So what I want to talk about now is shift a little bit to, what does that will or trust in most cases not cover at death? In other words, everyone has a will or trust. They think that's how their assets are going to pass. But a lot of it depends upon how the assets are owned and titled. So for example, if there's a joint with right of survivorship account with a spouse, no matter what the will says, that account's going to go directly to a spouse. Or if a person has added an adult child joint with right of survivorship to a bank account, then at death, that bank account is going to pass directly to that adult child. Another important type of asset that generally passes outside of a will or trust is your retirement plan or IRA. Those assets, as most of you know, have a beneficiary attached. That when you became an employee, when you changed employers, when you You created a rollover IRA because you were taking, rolling over a profit sharing or 401k from another employer. You were asked to complete a beneficiary designation. And that beneficiary designation supersedes the will. So if you have a beneficiary designation that leaves a spouse, but your will designates your children, the IRA is going to go to a spouse because that's what the beneficiary designation indicates. And IRAs were a major component of some legislation that's occurred within the past 12 months called the Secure Act. And basically, with an IRA after the Secure Act, if you, sort of like with the estate tax, if you leave your IRA or qualified retirement plan to a spouse, then that's going to pass free of estate tax, or excuse me, free of income tax to the spouse if the spouse rolls it over into a rollover IRA. Now, down the road, if the spouse starts taking monies, distributions from that IRA, then yes, the spouse is going to pay the income tax on that the same way as the IRA owner or participant in a retirement plan would pay income tax. But there's a free pass there for a spouse. But with the Secure Act, if a child or non-spousal beneficiary is designated, then under the Secure Act, the beneficiary can make an election to not take that distribution immediately upon death, but rather leave the IRA intact in something called a decedent's or an inherited IRA intact for 10 years, and then pull the funds out 10 years down the road. And it's at that 10-year point when the assets are pulled out that the tax would be paid. That's a good thing, in that you can stretch that payment of income tax out, you can defer it. Now, before the Secure Act, you could actually defer it a lot longer. So the Secure Act actually shortened the time period there. But there still are some important benefits that you want to make sure that you get. An important thing for a beneficiary is, even if a beneficiary of an IRA says, okay, I'm going to leave it in for 10 years, that's not an irrevocable election. So in other words, if a year down the road, all of a sudden, hey, let's buy a new house, I want to take a distribution from that IRA, you can still do that. It's not like an irrevocable thing where if you say 10 years, you can't touch it for 10 years. With certain scenarios, some of the asset protection issues we talked about, special needs situations that we talked about, or just needing for either a spouse or a beneficiary to create some structure because of concern of the ability to manage the assets. Sometimes a trust, would be necessary. And in the IRA retirement plan scenario, if you designate sort of a regular trust, then that deferment period shrinks from 10 years to 5 years if it's not done properly. But there's a right way to dot the I's and cross the T's to create a trust that can receive IRA and retirement plan assets that can be deferred for that same 10-year period that an individual beneficiary could defer. And a lot of that just depends on facts and circumstances, whether a trust is appropriate, the size of the IRA, retirement account, et cetera. But one thing that the Secure Act has done is, because that deferment has decreased from what used to be being able to defer it for the beneficiary's entire lifetime to shrinking it to 10 years, IRAs and retirement plans have become a pretty big source for clients who would like to make charitable gifts at death. Because as we talked about earlier on, gifts to charity are not subject to estate tax. We'll also now say that gifts to charity are not subject to income tax. So in a situation where a person could have has a large IRA or retirement plan, they believe they may be in an estate tax situation, you can see this huge IRA, and I'll even use the word shrink. I mean, it just begins to evaporate if you have to then pay income tax on the entire amount, or your beneficiary rather is paying income tax on the entire amount, plus if estate tax has to be paid on that amount. So you ultimately get to a situation where far less than 50% of that value actually passes to the designated beneficiary. Uncle Sam really becomes the primary beneficiary in those circumstances. So that's why for individuals who are charitably inclined, that the best place to make those charitable gifts upon death is out of IRAs or retirement plans, because if you have a $100,000 IRA and you leave that $100,000 IRA to a charity, then the charity gets the entire $100,000, doesn't pay estate tax or income tax on it. If it goes to an individual, income tax will be paid. No, I mean, there's no question about that. It's a matter of timing, but income tax will be paid. And then, and at whatever the beneficiary's rate is, both federal and state income tax. And then again, if it's an estate tax situation, it gets cut by another 40%. So again, to the extent there's any charitable inclination, an IRA is a good source, and it's cheap and easy to designate. All that has to be done is to update beneficiary designation with the IRA custodian or with the administrator of a retirement plan. So it doesn't require any sort of fancy or expensive legal document to do that. There certainly are other types of charitable planning that would maybe require a little bit more legal or tax advice and sometimes documentation. If for some reason there's a goal not to leave retirement assets, but to also leave other assets to charity, then a charity can be named as a simple recipient under a will or trust for a simple state of a certain amount of money, for a percentage of an estate, for certain real property if the charity is willing to accept the real property. So that's another pretty simple way of making a charitable gift or charitable bequest. But sometimes clients want to talk about a little more sophisticated planning for charities. For example, there's a technique called a charitable remainder unitrust. And that's a little bit of a mouthful, but it's really pretty simple. Just an example, I think, probably makes this one pretty simple. A person decides to put $250,000 in a charitable remainder trust, charitable remainder unitrust. Well, the grantor of the trust, so if it's you that is creating it, you would then retain the right to receive a percentage of that $250,000 on an annual basis. So you could say, and it needs to be somewhere between 5 and 10%, but you could receive the right to receive 5%, 6%, whatever that percent is that you would want back on that designation. And then, but then ultimately what remains at death or at the end of the term, I mean, a charitable remainder trust could be set up for 10 years rather than for life. I mean, it's not a cookie cutter type situation. But at the expiration of the term, whether that term is a number of years or is for the lifetime of the person that creates that charitable trust, the balance passes then to charity. And so that's great because you've made your charitable bequest. But with a charitable remainder trust, one of the great things is when you create this trust, one, you continue to get a little bit of a stream of income, which can be nice, depending upon where you are in life. But then the other thing is you're able to get an income tax deduction, a charitable deduction against your income tax during your life for putting this transaction into play that actually doesn't pass anything down to charity until many years down the road. So it's a way of creating a charitable deduction that sometimes can be useful. These charitable remainder trusts sometimes are created just because it's purely the will and desire of the client to create this great asset for a charity. There are other times that clients create these charitable remainder unit trusts for the tax benefit of doing it. Let's say that a person has highly appreciated stock. If they sell the stock, then they're going to pay capital gains tax. But if they create a charitable remainder trust and they transfer that stock into the trust then sells the stock. They're not going to initially pay that capital gains tax. And so it's a way of then getting that stream of income out over time in a more tax efficient manner, without having to pay that capital gains tax all at once, but then also getting that charitable deduction, which can also sometimes, offset some of some other either gain or income that comes in any given year.
Greg,
yeah.
may I interrupt just for 1 minute? I'm so glad you're covering these IRAs, as you referenced, and qualified retirement plans. A lot of people's wealth is built up there. One thing that we see in the charitable gift side is people are often surprised that it's not an all or nothing endeavor either. They can give a percentage of that to charity and a percentage to family or whomever else they want. So that's a consideration. And the other thing, not only for beneficiary designations, like I'm just talking about there, but in the trust realm, like you're speaking of, I know we hear oftentimes people say, I want to do something for my children and I want to do it in a tax advantageous manner. But number one, my children have different levels of being able to manage money. And number two, I want to leave them enough that helps them, but not enough that they can do nothing and not work during their lifetime. So are those things you hear from a planning side as well?
Definitely. Both in context of or in combination with charitable type planning, as well as sometimes not in conjunction with charitable planning. But yeah, I've had, clients, and we've done this a number of times, who have said, okay, I'd like to give as much as I can without estate tax to my children, but anything over that estate tax amount, I want to go to charity. I also, have had clients, and it's just sort of, and it's usually very interesting, very in-depth conversations, where, as you said, clients decide, hey, I've done well. I've earned this, or we as a couple have earned this, and we want to leave something to our children, but sort of as you said, Greg, but we don't want to leave them everything. And so there's situations, it's all across the board, as far as X amount to children, the balance to charity, X percentage to children, the remainder to charity. So, that's certainly not the everyday client that wants to do that. But it is something that we do experience on a regular basis. I think that when we were sort of putting together our agenda, if you will, for tonight's discussion, the goal was for me to wind up around 7:45 in order to have plenty of time for questions, discussion, etc. I know we haven't really had any, other than Greg, haven't had any questions during the talk, but I'm certainly happy to answer questions related to this topic, whether it's something I've covered in tonight's discussion or not. And I've not checked the little chat to see if anything popped up.
I've been keeping track of it, and thus far, no questions, but it wouldn't surprise me if some pop up now with this opportunity. I have one, though, that I hear quite a bit as well, and that is, I know you were talking, obviously, about estate tax thresholds and things of that nature. Some people would like to give things to their children while they're living, or to friends, not necessarily family members. And there are some opportunities through an annual exclusion and through some lifetime exclusions that you can gift things to children during your lifetime. I didn't know if you might just share a little bit about that for people watching.
Okay, yeah, that's perfect. So we talked earlier about an estate tax exemption, and we talked about how it currently is 11.58 million. Technically, that exemption is a lifetime gift and estate tax exemption. So it's something that you have, and so if you use part of it during your lifetime, then you have less at death. So in other words, if a high net worth client decided to gift $2 million to beneficiaries in 2020, then at the end of 2020, that client would have $9.58 million of exemption left that could be applied at death if that client did not make future gifts. But so that's generally the way that it works. But there's also a freebie here as well. And we refer to that as an annual exclusion gift. And the current amount for that is $15,000. So if a person makes an annual exclusion gift to an individual, or to as many individuals as the person wants to, those $15,000 gifts do not start eroding that lifetime gift and estate tax exemption. So a client who makes a $15,000 gift every single year for 20 years to 5 children, that client has not used any of that $11.58 million exemption. So that's an important exemption. There's a similar exemption for payment of medical expenses and educational expenses for anyone. With that, it has to go straight from the IRA, for instance, to the educational institution. You can't take a distribution from the IRA and then pay, a child's private school tuition or a grandchild's private school tuition. It would have to go directly to the educational facility.
Greg, also, I know you talked about the wonderful vehicle of a charitable remainder unit trust in retirement planning, but also, as you referenced, sometimes people acquire vacation homes, or they have business practices. A variety of things can help fund a charitable remainder trust and benefit either donor spouse, children, others. So just briefly speak, I guess, about the flexibility maybe of that vehicle.
Okay. So with the charitable remainder trust, as Greg said, I talked about that as I was winding up talking about IRAs, but it certainly can be, and most frequently is used with non-IRA, non-retirement plan assets. Whether it be cash, whether it be real estate, whether it be stocks and bonds. So really, any type of asset is an option for a charitable remainder trust. And the trust, can be designed. We talked about a 5% distribution back to the grantor or the person that creates the trust, but that 5, 6, 7%, whatever percent you would like to provide can be structured not only to come back to the grantor of the trust, it could go to the spouse, it could go to children. The impact there is on the charitable deduction. So I mentioned when you create a charitable remainder trust, one of the benefits is that you get a charitable deduction in year one, even though funds don't actually go to the charity until down the road. But the way that that charitable deduction is calculated, it's based on the value of the amount that you put in the charitable remainder trust. So let's say 250, but then you subtract from that 250 the actuarial value of the right to receive that 5% stream of income or whatever it is for a life expectancy or 10 years or whatever the term is. So if you fund it with 250, the charitable deduction is likely going to be less than 250, and the actual deduction depends on really sort of how long and how large that payment is that comes back to either the grantor of the trust or to other individual beneficiaries, non-charitable beneficiaries. We did a lot of charitable remainder trust. Things sort of come and go depending upon facts and circumstances. But when you're in a situation where there's a lot of highly appreciated real estate or stocks and bonds, a lot of times that's when we will really see people interested in the charitable remainder trust, because it does help convert an asset into a stream of income without being hit with as much capital gains tax. I know I said that earlier, but I thought it was sort of worthy of repeating. The other thing that I'll mention is that there are, my job sort of talk about the good, the bad, the ugly. I guess you all have to do that as physicians as well when you're talking with your patients. So another part of estate planning is something that we haven't really talked about thus far, and that is state law rights of spouses. So a lot of times with, say, second or successive marriages, there may be a desire to plan or to leave assets to children from a prior marriage or family from a prior marriage. And both spouses may be totally on board with that, initially. But North Carolina law has a fairly aggressive elective share statute. And basically what I mean by that is that a spouse has a certain entitlement to a deceased spouse's estate if that right wasn't waived by a premarital agreement, a postmarital agreement, or a separation agreement. And in North Carolina, these rules were revised in 2014, and that's when they became a little bit more aggressive. So basically, if a husband and wife have been married for 15 years, then a surviving spouse is entitled to 50% of the deceased spouse's assets. And that's sort of regardless of what the will says. Now, a surviving spouse would not have to take the action to cause that elective share right, that 50% to pass to the surviving spouse, but it needs to be part of the discussion during an estate plan if the substantial part of assets are not passing to or for the benefit of a spouse. And even if they're passing in trust for a spouse, sometimes the trust that we might talk about for estate tax purposes may not work as well for this elective share purpose. So, again, this is not sort of the fun stuff to talk about, but it's something that's important because if a person is spending the time, the effort, the money to create an estate plan, they want it to stick, upon death, obviously. And this elective share right is a right that can majorly impact that. And there's ways we can deal with that. Sometimes it's dealt with, particularly maybe in the second or successive spouse scenario. If you have two spouses, they both want to provide for their children. They're not really trying to provide for each other's children after death. A lot of times they may agree to waive those rights in a very simple document. or if it's not a situation like that where everybody's singing off the same page, then there's the ability to basically fund that elective share right. So let's say that that elective share right is 50%. Then a person could leave that 50% in a trust with a third party trustee who could manage it, make distributions for the spouse if the spouse needs those assets during his or her lifetime. But then ultimately, if the trustee doesn't determine that those assets are needed for the spouse during the spouse's lifetime, then what's left at that spouse's death would revert back to your beneficiaries. So that's something that is important as well, or can be.
Well, I know that we had sort of said we wanted a hard stop at an hour this evening. And so, Greg, I just want to thank you again for sharing this wonderful and valuable professional knowledge with us and our beloved alumni and friends of the Brody School of Medicine. I want to thank our guests again for your valuable time in attending this evening. Please know that we're glad to follow up from the Medical and Health Sciences Foundation or from a plan giving standpoint via email, phone, virtual call, or in person at an appropriate time. And I can promise you, knowing how busy doctor schedules are, that we can be readily available on nights, early mornings, weekends, or around that time frame, appreciating how important what you're doing as a practice is on a daily basis. Our goal with these is to try to provide valuable information that helps our alumni understand legislation and important estate planning documents to help protect your families and also try to fulfill your philanthropic objectives. Finally, this evening, I guess in this unprecedented time of pandemic, I know personally I reflect on how thankful I am for our Brody School of Medicine and Health Sciences. Their impact on our students, on healthcare in our region and state and nation is so vital right now, and what a great resource to be proud of at East Carolina University. So with that, I just wish you all good health and safety. And I hope that we have a chance to have some other conversations moving forward in the future that might impact your philanthropic planning. And we have the capability to do everything from the extremely simple of bequest provisions to beneficiary designations to trusts and gift annuities and everything in between. So thank you for your time tonight. And thank you for your interest and support in the East Carolina University Medical and Health Sciences Foundation.
Thank y'all.